Crimes against national security. Article 114 Treason. Elements. 1. That the offender is a Filipino citizen, or an alien residing in the Philippines. 2. That there is a war in which the Philippines is involved, and 3. That the offender either a. levies war against the government, or b. adheres to the enemies, giving them aid or comfort. Treason is a breach of allegiance to a government, committed by a person who owes allegiance to it. Treason cannot be committed in times of peace because there are no traitors until war has started. Formal declaration of the existence of a state of war is not necessary. Levying war. This requires the concurrence of 2 things. 1. That there be an actual assembling of men, and 2. For the purpose of executing a treasonable design by force. The levying of war must be with intent to overthrow the government, not merely to resist a particular statute or to repel a particular officer. Article 115. Conspiracy and proposal to commit treason. Elements of conspiracy to commit treason. 1. In times of war. 2. Two or more persons come to an agreement to a. levy war against the government, or b. adhere to enemies and to give them aid or comfort, and 3. They decide to commit it. Elements of proposal to commit treason. 1. In times of war. 2. A person who has decided to levy war against the government, or to adhere to the enemies and give them aid and comfort, and 3. proposes its execution to some other person or persons. Article 116. Misprision of treason. 1. That the offender who is not a foreigner must be owing allegiance to the government. 2. That he has knowledge of any conspiracy to commit treason against the government, and 3. That he conceals or does not disclose or make known the same as soon as possible to the governor or fiscal of the province or mayor or fiscal of the city in which he resides. This crime is an exception to the rule that mere silence does not make a person criminally liable. It is a crime of omission. Article 116 does not provide for a penalty, but the offender is punished as an accessory to the crime of treason. Therefore, the penalty is 2 degrees lower than that provided for treason. Article 117. Espionage. 1. By entering, without authority therefore, a warship, fort, or naval or military establishment or reservation to obtain any information, plans, photographs, or other data of a confidential nature relative to the defense of the Philippines. Elements. A. That the offender enters in any place mentioned therein. B. That he has no authority therefore, and c. That his purpose is to obtain information, plans, photographs, or other data of confidential nature relative to the defense of the Philippines. 2. By disclosing to the representative of a foreign nation the contents of the articles, data, or information referred to in the preceding paragraph, which he had in his possession by reason of the public office he holds. Elements. A. That the offender is a public officer. B. That he has in his possession the articles, data, or information referred to in paragraph number 1 of Article 117. By reason of the public office he holds, and c. That he discloses their contents to a representative of a foreign nation. Article 118. Inciting to war or giving motives for reprisals. Elements. 1. That the offender performs unlawful or unauthorized acts, and 2. That such acts provoke or give occasion for a war involving or liable to involve the Philippines or expose Filipino citizens to reprisals on their persons or property. The crime of inciting to war or giving motives for reprisals is committed in time of peace. Reprisal. It is any kind of forcible or coercive measure whereby one state seeks to exercise a deterrent effect or to obtain redress or satisfaction, directly or indirectly, for consequences of the illegal acts of another state which has refused to make amends for such illegal conduct. Reprisals are not limited to military action. It could be economic reprisals or denial of entry into their country. Article 119. Violation of neutrality. Elements. 1. That there is a war in which the Philippines is not involved. 2. That there is a regulation issued by a competent authority for the purpose of enforcing neutrality, and 3. That the offender violates such regulation. Neutrality is a condition of a nation that, in times of war, takes no part in the dispute but continues peaceful dealings with the belligerents. The regulation must be issued by competent authority like the President of the Philippines or the Chief of Staff of the Armed Forces of the Philippines, during a war between different countries in which the Philippines is not taking sides. Article 120. Correspondence with hostile country. Elements. 1. There is a war in which the Philippines is involved. 2. That the offender makes correspondence with an enemy country or territory occupied by enemy troops, and 3. That the correspondence is either a. Prohibited by the government, or b. Carried on in ciphers or conventional signs, or c. Containing notice or information which might be useful to the enemy. Correspondence is communication by means of letters, or it may refer to the letters which pass between those who have friendly or business relation. Even if the correspondence contains innocent matters, but the correspondence has been prohibited by the government, it is still punishable. Article 121. Flight to enemy's country. Elements. 1. That there is a war in which the Philippines is involved. 2. That the offender must be owing allegiance to the government. 3. That the offender attempts to flee or go to enemy country, and 4. That going to enemy country is prohibited by competent authority. It should be noted that the mere attempt to flee or go to enemy country when prohibited by competent authority consummates the felony. Alien residents, not only Filipino citizens, can be held liable under this article. That law does not say not being a foreigner. Hence, allegiance herein may be permanent or temporary. Article 122. Piracy in general and mutiny in the high seas or in Philippine waters. 2 modes of committing piracy. 1. By attacking or seizing a vessel on the high seas, or 2. By seizing the vessel while on the high seas or the whole or part of its cargo, its equipment or personal belongings of its complement or passengers, by non-passengers or non-members of the crew. Elements. 1. That a vessel is on the high seas or in the Philippine waters. 2. That the offenders are not members of its complement or passengers of the vessel, and 3. That the offenders either a. Attack or seize that vessel, or b. Seize the whole or part of the cargo of said vessel, its equipment or personal belongings of its complement or passengers. Pirates are in law hostes humani generis. Piracy is a crime not against any particular state but against all mankind. It may be punished in the competent tribunal of any country where the offender may be found or into which he may be carried. The jurisdiction of piracy, unlike all other crimes, has no territorial limits. Piracy under RPC and PD 532 compared. RPC can be committed while the vessel is on high seas or in Philippine waters, can only be committed by persons who are not members of the vessel's complement, or the passengers of the vessel. PD 532 can be committed only when the vessel is in Philippine waters. Can be committed by any persons, including the vessel's complement, or the passengers of the vessel. Article 123. Qualified piracy. Circumstances qualifying the crimes of piracy and mutiny. 1. Whenever they have seized a vessel by boarding or firing upon the same. 2. Whenever the pirates have abandoned their victims without means of saving themselves, or 3. Whenever the crime is accompanied by murder, homicide, physical injuries, or rape. Article 128. Violation of domicile. Modes of commission. 1. Entrance to dwelling against the will of the owner. 2. Search without previous consent of owner. Elements. 1. Offender is a public officer or employee. 2. He is not authorized by judicial order. 3. He performed the following acts. A. Entered the dwelling against the will of the owner. B. Searched for papers or other effects therein without the previous consent of such owner, or c. Refused to leave the premises, after having surreptitiously entered such dwelling and having been required to leave the same. Qualifying circumstances: 1. Nighttime, or 2. Papers or effects not constituting evidence of a crime are not returned immediately after the search. Article 129. Search warrants maliciously obtained and abuse in the service of those legally obtained. 1. Procuring search warrant without just cause. Elements: A. Offender is a public officer or employee. B. He procures a search warrant. C. There is no just cause. 2. Exceeding authority or using unnecessary severity in the execution. Elements: A. Offender is a public officer or employee. B. He has already legally procured a search warrant. C. He exceeds his authority or uses unnecessary severity in executing the same. Article 130. Searching domicile without witnesses. Elements: 1. Offender is a public officer or employee. 2. He is armed with search warrant legally procured. 3. He searches the domicile, papers, or other belongings of any person. 4. The owner, or any members of his family, or 2 witnesses residing in the same locality are not present. Article 131. Prohibition, interruption, and dissolution of peaceful meetings. Committed by a public officer or employee. Acts punished: 1. Prohibiting, interrupting, or dissolving, without legal ground, the holding of a peaceful meeting. 2. Hindering any person from joining any lawful association, or attending any of its meetings. 3. Prohibiting or hindering any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses, or redress of grievances. Crimes against religious worship. Article 132. Interruption of religious worship. Elements: 1. Offender is a public officer or employee. 2. Religious ceremonies or manifestations of any religion are about to take place or are going on. 3. Offender prevents or disturbs the same. Qualifying circumstance: if the crime is committed with violence or threats. Article 133. Offending the religious feelings. Elements: 1. Acts complained of were performed: A. in a place devoted to religious worship, or B. during the celebration of any religious ceremony. 2. The acts must be notoriously offensive to the feelings of the faithful. Acts notoriously offensive to feelings: 1. Ridicules or makes light of anything constituting religious dogma. 2. Works or scoffs at anything devoted to religious ceremonies. 3. Plays with or damages or destroys any object of veneration of the faithful. Crimes against public order. Article 134. Rebellion or insurrection. Elements: 1. There be A. Public uprising, and B. Taking arms against government. 2. Purpose of the uprising or movement is either to A. Remove from the allegiance to said government or its laws. I. The territory of the Philippines or any part thereof, or 2. Any body of land, naval or other armed forces, or B. Deprive the Chief Executive or Congress, wholly or partially, of any of their powers or prerogative. Essence of rebellion. The essence of rebellion is public uprising and the taking of arms. It aims to overthrow the duly constituted government. It is generally carried out by civilians. Note: if there is no public uprising, the crime is direct assault. The use of unlicensed firearm is absorbed in the crime of rebellion if used in furtherance of or incident to, or in connection with the crime of rebellion, or insurrection, or sedition. Also, if the act is to deprive the judiciary of its power or prerogatives, the crime committed is sedition. Article 134. A coup d'etat. Elements: 1. Offender is a person or persons belonging to military or police or holding any public office or employment. 2. It is committed by means of a swift attack accompanied by violence, intimidation, threat, strategy, or stealth. 3. Attack is directed against duly constituted authorities of the Republic of the Philippines or any military camp or installation, communication networks, public utilities, or other facilities needed for the exercise and continued possession of power. 4. Purpose of the attack is to seize or diminish state power. Article 135. Penalty for rebellion, insurrection, or coup d'etat. Persons liable for rebellion, insurrection, or coup d'etat. 1. The leaders. A rebellion or insurrection: any person who promotes, maintains, or heads a rebellion or insurrection, or b. Coup d'etat: any person who leads, directs, or commands others to undertake a coup d'etat. 2. The participants. A rebellion or insurrection: any person who participates or executes the commands of others. b. Coup d'etat. I. Any person in the government service who participates or executes directions or commands of others, or 2. Any person not in the government service who participates, supports, finances, abets or aids in undertaking a coup d'etat. Article 136. Conspiracy and proposal to commit coup d'etat, rebellion, or insurrection. Conspiracy to commit rebellion. There is conspiracy to commit rebellion when 2 or more persons come to an agreement to rise publicly and take arms against the government for any of the purposes of rebellion and decide to commit it. Proposal to commit rebellion. There is proposal to commit rebellion when the person who has decided to rise publicly and take arms against the government for any of the purposes of rebellion proposes its execution to some other person or persons. Note: the advocacy to communism is not tantamount to conspiracy to commit rebellion because mere advocacy of theory or principle is insufficient to constitute conspiracy to commit rebellion unless the advocacy is converted into action. Also, the mere fact of giving and rendering speeches favoring communism would not make the accused guilty of conspiracy, if there is no evidence that the hearers then and there agreed to rise up in arms against the government. Article 137. Disloyalty of public officers or employees. Elements. 1. Offender is a public officer or employee. 2. Offender commits any of the following acts. A. Failing to resist a rebellion by all the means in their power. B. Continuing to discharge the duties of their offices under the control of the rebels. C. Accepting appointment to office under them. Article 138. Inciting a rebellion or insurrection. Elements. 1. Offender does not take arms or is not in open hostility against the government. 2. He incites others to the execution of any of the acts of rebellion. 3. Inciting is done by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end. Article 139. Sedition. Elements. 1. Offender rise. A. Publicly, and b. Tumultuously. 2. They employ force, intimidation, or other means outside of legal methods. 3. Offenders employ any of those means to attain any of the following objects to a. Prevent the promulgation or execution of any law or the holding of any popular election. b. Prevent the national government, or any public officer from freely exercising its or his functions, or prevent the execution of any administrative order. c. Inflicting any act of hate or revenge of any person or property of any public officer or employee. d. Commit, for any political or social end, any act of hate or revenge against private persons or any social cases. e. Despoil, for any political or social end, any person, municipality, or province, or the national government of all its property or any part thereof. Article 140. Penalty for sedition. The leader of a sedition shall suffer the penalty of prison mayor in its minimum period and a fine not exceeding 10,000 pesos. Other persons participating therein shall suffer the penalty of prison correctional in its maximum period and a fine not exceeding 5,000 pesos. Article 141. Conspiracy to commit sedition. Elements. 1. 2 or more persons come to an agreement and a decision to rise publicly and tumultuously to attain any of the objects of sedition. 2. They decide to commit it. Note: there is no proposal to commit sedition. To be liable, there must be an agreement and determination to rise publicly and tumultuously to attain any of the objects specified in Art. 139. Article 142 Inciting to sedition. Punishable acts in the crime of inciting to sedition. 1. Inciting others to the accomplishment of any of the acts which constitute sedition by means of speeches, proclamations, writings, emblems, etc. 2. Uttering seditious words or speeches which tend to disturb the public peace. 3. Writing, publishing or circulating scurrilous libels against the government or any of the duly constituted authorities thereof, which tend to disturb the public peace. Scurrilous means low, vulgar, mean, or foul. Note: it is the use of words, emblems, etc., and not the performance of an act that is punished in inciting to sedition. In inciting to sedition, the offender must not take part in any public or tumultuous uprising. Uttering seditious words/speeches and writing, publishing or circulating scurrilous libels are punishable when they 1. Tend to disturb or obstruct any lawful officer in executing the functions of his office. 2. Tend to instigate others to cabal and meet together for unlawful purposes. 3. Suggest or incite rebellious conspiracies or riots. 4. Lead or tend to stir up the whole people against the lawful authorities or to disturb the peace of the community, the safety and order of the government. 2. Rules relative to seditious words. 1. Clear and present danger rule. Words must be of such nature that by uttering them there is a danger of public uprising and that such danger should be both clear and imminent. 2. Dangerous tendency rule. If words used tend to create a danger of public uprising, then those words could properly be subject of penal clause. Some instances of inciting to sedition. 1. Meeting for the purpose of discussing hatred against the government. 2. Lambasting government officials to discredit the government. Article 143 Act tending to prevent the meeting of the Assembly and similar bodies. Elements. 1. There be projected or actual meeting of the Congress or any of its committees or subcommittees, constitutional committees or divisions thereof, or of any provincial board or city or municipal council or board. 2. Offender, who may be any person, prevents such meeting by force or fraud. Note: the Chief of Police and Mayor who prevented the meeting of the Municipal Council are under Article 143. When the defect of the meeting is not manifest and requires an investigation before its existence can be determined. Article 144 Disturbance of proceedings. Elements. 1. There is a meeting of Congress or any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or any provincial board or city or municipality council or board. 2. Offender does any of the following acts. A. Disturbs any such meetings, or B. Behaves while in the presence of any such bodies, in such a manner as to interrupt its proceedings or to impair the respect due it. Note: the implied power to punish for contempt of the National Assembly is coercive in nature. The power to punish crime is punitive in character. Thus, the same act could be made the basis for contempt proceedings and for criminal prosecution. The disturbance can be in the form of utterances, speeches, or any form of expressing dissent which is done in such a manner as to interrupt its proceedings or to impair the respect due it. If the meeting disturbed is one attended by municipal officials called by the mayor, the offender is not liable under Article 144 because this article presupposes that the meeting disturbed is that of a legislative body or of provincial, city or municipal council or board. Article 145 Violation of parliamentary immunity. Punishable acts in violation of parliamentary immunity. 1. Using force, intimidation, threats, or frauds to prevent any member of Congress from A. Attending the meetings of Congress or of any of its committees or subcommittees, constitutional commissions or committees. B. Expressing his opinions. C. Casting his vote. The offender in this case may be any person. 2. Arresting or searching any member thereof while Congress is in regular or special session, except in case such member has committed a crime punishable under the Code by a penalty higher than prison mayor. It is not necessary that the member is actually prevented from exercising any of his functions. It is sufficient that Congress is in session and the offender, in using force and intimidation, threats, or fraud, has the purpose to prevent a member of the Congress from exercising any of such prerogatives. Note: parliamentary immunity does not protect members of Congress from responsibility before the legislative body itself. Article 146 Illegal Assemblies. Forms of illegal assemblies and their elements. 1. Any meeting attended by armed persons for the purpose of committing any of the crimes punishable under the RPC. Elements. A. There is a meeting, a gathering, or group of persons, whether in fixed place or moving. B. The meeting is attended by armed persons, and C. The purpose of the meeting is to commit any of the crimes punishable under the RPC. 2. Any meeting in which the audience, whether armed or not, is incited to the commission of the crime of treason, rebellion, or insurrection, sedition, or assault upon a person in authority or his agents. Elements. A. There is a meeting, a gathering group of persons, whether in a fixed place or moving, and B. The audience, whether armed or not, is incited to the commission of the crime of treason, rebellion, or insurrection, sedition or direct assault. Note: if the person present carries an unlicensed firearm, the presumption, insofar as he is concerned, is that the purpose of the meeting is to commit acts punishable under this code, and that he is the leader or organizer of the meeting. Gravamen of a legal assembly. The gravamen of a legal assembly is mere assembly of or gathering of people for a legal purpose punishable by the RPC. Without gathering, there is no illegal assembly. Persons liable for illegal assembly. The persons liable are 1. Organizers or leaders of the meeting, and 2. Persons merely present at the meeting. Note: if the illegal purpose for the gathering is for the commission of a crime punishable under special laws, the gathering of drug lords to facilitate drug trafficking, illegal assembly is not committed, because if the unlawful purpose is a crime under a special law, there is no illegal assembly. The crime committed would be illegal association. Article 147 Illegal associations. Illegal associations. 1. Associations totally or partially organized for the purpose of committing any of the crimes punishable under the RPC. 2. Associations totally or partially organized for some purpose contrary to public morals. Public morals. It refers to matters which affect the interest of society and public inconvenience and are not limited to good customs. It refers to acts that are in accordance with natural and positive laws. Persons liable for the crime of illegal associations. 1. Founders, directors and president of the association, and 2. Mere members of the association. Article 148. Direct assault. 2 ways of committing the crime direct assault. First, without public uprising, by employing force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition. Elements. 1. Offender employs force or intimidation. 2. The aim of the offender is to attain any of the purposes of the crime of rebellion or any of the objects of the crime of sedition, and 3. There is no public uprising. Second, without public uprising, by attacking, by employing force, or by seriously intimidating or seriously resisting any person in authority or any of his agents, while engaged in the performance of official duties, or on the occasion of such performance. 1. The offender a. employs force, b. makes an attack, c. makes a serious intimidation, or d. makes a serious resistance. 2. The person assaulted is a person in authority or his agent. 3. That at the time of the assault the person in authority or his agent a. is engaged in the actual performance of official duties, or that he is assaulted b. by reason of the past performance of official duties. 4. That the offender knows that the one he is assaulting is a person in authority or his agent in the exercise of his duties. Qualified direct assault. Direct assault is qualified when 1. Assault is committed with weapon. 2. The offender is a public officer or employee, or 3. Offender lays hands upon a person in authority. Article 149. Indirect assault. Elements. 1. A person in authority or his agent is the victim of any of the forms of direct assault defined in Article 148. 2. A person comes to the aid of such authority of his agent. 3. Offender makes use of force or intimidation upon such person coming to the aid of the authority or his agent. Note: indirect assault presupposes that direct assault was committed. Article 150. Disobedience to summons issued by the Congress, its committees or subcommittees, by the constitutional commissions, its committees, subcommittees or division. Acts punishable. 1. By refusing, without legal cause, to obey summons of the Congress, its special or standing committees and subcommittees, the constitutional commissions and its committees, subcommittees or divisions, or by any commission or committee chairman or member authorized to summon witnesses. 2. By refusing to be sworn or placed under affirmation while being before such legislative or constitutional body or official. 3. By refusing to answer any legal inquiry or to produce any books, papers, documents, or records in his possession, when required by them to do so in the exercise of their functions. 4. By restraining another from attending as a witness in such legislative or constitutional body. 5. By inducing disobedience to a summons or refusal to be sworn by any such body or official. Article 151. Resistance and disobedience to a person in authority or the agents of such person. Punishable acts. First, resistance and serious disobedience. Elements: 1. That a person is authority or his agent is engaged in the performance of official duty or gives a lawful order to the offender. 2. That the offender resists or seriously disobeys such person in authority or his agent. 3. That the act of the offender is not included in the provisions of Articles 148, 149 and 150. Second, simple disobedience. Elements: 1. That an agent of a person in authority is engaged in the performance of official duty or gives a lawful order to the offender. 2. That the offender disobeys such agent of a person in authority. 3. That such disobedience is not of a serious nature. Article 152. Persons in authority and agents of persons in authority. A person in authority is one directly vested with jurisdiction, which meant the power and authority to govern and execute laws. Agent of person in authority. Person charged with 1. Maintenance of public order, and 2. Protection and security of life and property. Article 153. Tumults and other disturbances of public order. Acts punishable. 1. Causing any serious disturbance in a public place, office, or establishment. 2. Interrupting or disturbing performances, functions, or gatherings, or peaceful meetings, if the act is not included in Articles 131. Prohibition, interruption, and dissolution of peaceful meetings, and 132. Interruption of religious worship. 3. Making any outcry tending to incite rebellion or sedition in any meeting, association, or public place. 4. Displaying placards or emblems which provoke a disturbance of public order in such place. 5. Burying with pomp the body of a person who has been legally executed. Qualifying circumstance, if the disturbance or interruption caused is of a tumultuous character. Article 154. Unlawful use of means of publication and unlawful utterances. Punishable acts. 1. Publishing or causing to be published, by means of printing, lithography, or any other means of publication. As news any false news which may endanger the public order, or cause damage to the interest or credit of the state. 2. Encouraging disobedience to the law or to the constituted authorities or praising, justifying, or extolling any act punished by law, by the same means or by words, utterances, or speeches. 3. Maliciously publishing or causing to be published any official document or resolution without proper authority, or before they have been published officially. 4. Printing, publishing, or distributing, or causing the same, books, pamphlets, periodicals, or leaflets which do not bear the real printer's name, or which are classified as anonymous. Note: actual public disorder or actual damage to the credit of the state is not necessary. The mere possibility of causing such danger or damage is sufficient. Article 155. Alarms and scandals. Punishable acts. 1. Discharging any firearm, rocket, firecracker, or other explosive within any town or public place, calculated to cause, which produces, alarm or danger. 2. Instigating or taking an active part in any chivalry or other disorderly meeting offensive to another or prejudicial to public tranquility. 3. Disturbing the public peace while wandering about at night or while engaged in any other nocturnal amusements. 4. Causing any disturbances or scandal in public places while intoxicated or otherwise, provided Article 153, tumults and other disturbances of public order, is not applicable. Under Article 153, disturbance must be of a serious nature. Article 156. Delivering prisons from jails. Elements. 1. There is a person confined in a jail or penal establishment, and 2. Offender removes therefrom such person or helps the escape of such person. Consent or connivance necessary to hold public officer guilty. It is necessary that the public officer had consented to, or connived in, the escape of the prisoner under his custody or charge. Officer must not be the custodian of the prisoner. If the offender is a public officer who had the prisoner in his custody or charge, he is liable for infidelity in the custody of a prisoner under Article 223. If 3 persons are involved, the crimes committed are as follows. 1. Conniving with or consenting to evasion, Article 223, committed by a public officer who is in custody or charge of the prisoner. 2. Delivering prisoners from jail, Article 156, committed by the stranger who helped in the escape. 3. Evasion of service of sentence, Article 157, committed by the prisoner who escaped. Article 157. Evasion of service of sentence by escaping during the term of his sentence. Elements. 1. Offender is a convict by final judgment. 2. He is serving sentence which consists in the deprivation of liberty. 3. He evades service of his sentence by escaping during the term of his imprisonment. Qualifying circumstances as to penalty imposed if such evasion or escape takes place. 1. By means of unlawful entry, this should be by scaling. 2. By breaking doors, windows, gates, walls, roofs or floors. 3. By using picklock, false keys, disguise, deceit, violence or intimidation, or 4. Through connivance with other convicts or employees of the penal institution. Article 158. Evasion of service of sentence on the occasion of disorders. Elements. 1. Offender is a convict by final judgment, who is confined in a penal institution. 2. There is disorder, resulting from a. Conflagration, b. Earthquake, c. Explosion, d. Similar catastrophe, or e. Mutiny in which he has not participated. 3. He evades the service of his sentence by leaving the penal institution where he is confined, on the occasion of such disorder or during the mutiny. 4. He fails to give himself up to the authorities within 48 hours following the issuance of a proclamation by the chief executive announcing the passing away of such calamity. Failure to return, leaving the penal establishment is not the basis of criminal liability. What is punished is the failure to return within 48 hours after the passing of the calamity, conflagration, or mutiny had been announced. Effect of surrendering within 48 hours. Convicts who shall give themselves up to the authorities within 48 hours from the issuance of a proclamation, shall be entitled to the deduction provided for under Art. 98, 1/5 of the period of his sentence. Article 159, Other cases of evasion of service of sentence, by violating the conditions of conditional pardon. Elements. 1. Offender was a convict. 2. He was granted a conditional pardon by the chief executive, and 3. He violated any of the conditions of such pardon. Article 160, Commission of another crime during service of penalty imposed for another previous offense. Elements: 1. Offender was already convicted by final judgment of one offense. 2. He committed a new felony before beginning to serve such sentence or while serving the same. Pardon. Pardon is to be given to a convict who 1. Is not a habitual criminal. 2. Is already at the age of 70 years, and 3. Has already served out his original sentence or if he completing it after reaching such age. Exception: if by reason of his conduct, he is deemed not worthy of such clemency. Quasi-recidivism: a special aggravating circumstance where a person, after having been convicted by final judgment, shall commit a new felony before beginning to serve such sentence, or while serving the same. He shall be punished by the maximum period of the penalty prescribed by law. As to the act committed, the first crime for which the offender is serving sentence need not be a felony. Article 161. Counterfeiting the Great Seal of the Government of the Philippine Islands. Forging the signature or stamp of the Chief Executive. Acts punished: forging the 1. Great Seal of the Government of the Philippines. 2. Signature of the President, or 3. Stamp of the President. Article 162. Using forged signature or counterfeit seal or stamp. Elements: 1. The Great Seal of the Republic was counterfeited or the signature or stamp of the Chief Executive was forged by another person. 2. Offender knew of the counterfeiting or forgery, and 3. He used the counterfeit seal or forged signature or stamp. Note: offender under this article should not be the forger. Otherwise, he will be penalized under Article 161. The participation of the offender is in effect that of an accessory. Although the general rule is that he should be punished by a penalty of 2 degrees lower. Under Article 162 he is punished by a penalty only 1 degree lower. Article 163. Making and importing and uttering false coins. Elements: 1. There be false or counterfeited coins. 2. Offender either made, imported, or uttered such coins. 3. In case of uttering such false or counterfeited coins, he connived with the counterfeiters or importers. Kinds of coins covered by the crime. 1. Silver coins of the Philippines or coin of the Central Bank, CB. 2. Coins of minor coinage of the Philippines or CB, or 3. Coin of the currency of a foreign country. Article 164. Mutilation of coins. Acts punished: 1. Mutilating coins of the legal currency, or 2. Importing or uttering such mutilated coins. Elements of mutilation: 1. Coin mutilated is of legal tender, and 2. Offender gains from the precious metal dust abstracted from the coin. Mutilation means to take off part of the metal either by filling it or substituting it for another metal of inferior quality. Elements of importing or uttering mutilated coins: 1. Offender imported or uttered mutilated coins, and 2. In case of uttering, the offender must have connived with the mutilator or importer. Article 165. Selling of false or mutilated coin, without connivance. Acts punished: 1. Possession of coin, counterfeited or mutilated by another person, with intent to utter the same, knowing that it is false or mutilated, or 2. Actually uttering such false or mutilated coin, knowing the same to be false or mutilated. Constructive possession. Possession prohibited in this article is not only actual and physical possession, but also that of a constructive one, or the subjection of the thing to one's control. The possessor should not be the counterfeiter, mutilator, or importer of the coins. Making and importing and uttering. Article 166. Forging treasury or banknotes or other documents payable to bearer, importing and uttering such false or forged notes and documents. Elements: 1. There is an instrument payable to bearer, and 2. The offender commits any of the following acts: a. Forged or falsified a treasury or banknote or a document payable to bearer. B. Imported such false or forged obligations or notes, or C. Uttered such false or forged obligations or notes in connivance with the forgers or importers therein. Article 167. Counterfeiting, importing, and uttering instruments not payable to bearer. Elements. 1. There is an instrument payable to order or other document of credit not payable to bearer. 2. Offender either forged, imported, or uttered such instrument, and 3. In case of uttering, he connived with the forger or importer. He connived with the forger or importer. Article 168. Illegal possession and use of false treasury or bank notes and other instruments of credit. Elements. 1. Any treasury or bank note or certificate or other obligation and security. A. There is an instrument payable to bearer, to order or other document of credit not payable to bearer. B. Said instrument is forged or falsified by another person. 2. Offender knows that any of those instruments is forged or falsified, and 3. He either A. Uses any of such forged or falsified instruments, or B. Possesses the same, with intent to use. Presumption of material author. The rule is that if a person had in his possession a falsified document and he made use of it, taking advantage of it and profiting thereby, the presumption is that he is the material author of the falsification. Article 169. How forgery is committed. Acts punished. 1. By giving to a treasury or bank note or any instrument payable to bearer or to order mentioned therein, the appearance of a true and genuine document, or 2. By erasing, substituting, counterfeiting, or altering by any means the figures, letters, words, or sign contained therein. Article 170. Falsification of legislative documents. Elements. 1. There is a bill, resolution, or ordinance enacted or approved or pending approval by either house of the legislature or any provincial board or municipal council. 2. Offender alters the same. 3. He has no proper authority, and 4. Alteration has changed the meaning of the documents. Article 171. Falsification by public officer, employee, or notary or ecclesiastical minister. Elements. 1. Offender is a public officer, employee, or notary public. 2. He takes advantage of his official position and 3. He falsifies a document by committing any of the following acts. A. Counterfeiting or imitating any handwriting, signature, or rubric. B. Causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. C. Attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. D. Making untruthful statements in a narration of facts. E. Altering true dates. F. Making any alteration or intercalation in a genuine document which changes its meaning. G. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to, or different from, that of the genuine original and H. Intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. Paragraph 1. Counterfeiting or imitating any handwriting, signature, or rubric. Acts punished. 1. Counterfeiting imitating any handwriting, signature, or rubric or a. There should be an intent to imitate, or an attempt to imitate. B. 2 signatures, the genuine and the forged, should bear some resemblance. 2. Imitating, simulating a signature, handwriting, or rubric out of one which does not actually exist. Paragraph 2. Causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. Elements. 1. Offender caused it to appear in a document that a person participated in an act or proceeding. 2. Such person did not in fact participate. Paragraph 3. Attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. Elements. 1. Person participated in an act or proceeding. 2. Such person made statements in that act or proceeding and 3. Offender, in making a document, attributed to such person statements other than those they in fact made. Paragraph 4. Making untruthful statements in a narration of facts. Elements. 1. Offender makes in a document statements in a narration of facts. 2. He has a legal obligation to disclose truth of facts. 3. Facts narrated are absolutely false and 4. Perversion of truth in the narration was made with the wrongful intent of injuring a third person. Paragraph altering true dates. Elements. 1. Date must be essential. 2. Alteration of the date must affect the veracity of the documents or the effects thereof, such as dates of birth, marriage, or death. Date must be essential. Falsification under this paragraph only when the date mentioned in the document is essential. The alteration of the date or dates in a document must affect either the veracity of the document or the effects thereof. The dates of birth, marriage, and death are essential, because without them the documents cannot produce any legal effect. Paragraph 6. Making any alteration or intercalation in a genuine document which changes its meaning. Elements. 1. There be an alteration, or intercalation on a document. 2. It was made on a genuine document. 3. Alteration or intercalation has changed the meaning of the document. 4. Change made the document speak something false. Change or insertion must affect the integrity of the document. Furthermore, the alteration should make the document speak something false, otherwise, it would merely be a correction. Paragraph 7. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to, or different from, that of the genuine original. Persons liable. 1. Custodian authentication of a document can only be made by the custodian or the one who prepared and retained a copy of the original purporting to be a copy of the original when no such original exists, b. including in a copy a statement contrary to, or different from, that of the genuine original. 2. Private person. A private person who cooperates with a public officer in the falsification of a public document is guilty of the crime and incurs the same liability and penalty. Paragraph intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. Falsification of public, official or commercial document by a private individual. Elements. 1. Offender is a private individual or public officer or employee who did not take advantage of his official position. 2. He committed any act of falsification. 3. The falsification was committed in a public, official, or commercial document or letter of exchange. Falsification of private document by any person. Elements. 1. Offender committed any of the acts of falsification except Article 171(7), that is, a. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or b. Including in such a copy a statement contrary to, or different from, that of the genuine original. 2. Falsification was committed in any private document. 3. Falsification causes damage to a third party, or at least the falsification was committed with intent to cause such damage. Use of falsified document. Elements in introducing in a judicial proceeding. 1. Offender knew that the document was falsified by another person. 2. The false document is in Articles 171 or 172 (1 or 2). 3. He introduced said document in evidence in any judicial proceeding. Elements in use in any other transaction. 1. Offender knew that a document was falsified by another person. 2. False document is embraced in Articles 171 or 172 (1 or 2). 3. He used such document. 4. The use caused damage to another or at least used with intent to cause damage. At least used with intent to cause damage. Article 173. Falsification of wireless, cable, telegraph, and telephone messages, and use of said falsified messages. Uttering fictitious wireless, telegraph, or telephone message. Elements. 1. Offender is an officer or employee of the government or an officer or employee of a private corporation, engaged in the service of sending or receiving wireless, cable, or telephone message, and 2. He utters fictitious wireless, cable, telegraph, or telephone message. Falsifying wireless, telegraph, or telephone message. Elements. 1 offender is an officer or employee of the government or an officer or employee of a private corporation, engaged in the service of sending or receiving wireless, cable, or telephone message and 2. He falsifies wireless, cable, telegraph, or telephone message, using such falsified message. Elements. 1 offender knew that wireless, cable, telegraph, or telephone message was falsified by an officer or employee of the government or an officer or employee of a private corporation engaged in the service of sending or receiving wireless, cable or telephone message. 2. He used such falsified dispatch and 3. The use resulted in the prejudice of a third party or at least there was intent to cause such prejudice. Article 174. False medical certificates, false certificates of merits of service, etc. Persons liable. 1 physician or surgeon issues a false certificate in connection with the practice of his profession. It must refer to the illness or injury of a person. 2 public officer issues a false certificate of merit of service, good conduct or similar circumstances or 3 private person falsifies a certificate falling within the classes mentioned in the 2 preceding subdivisions. Elements. 1 false certificate was issued by the following. A physician or surgeon issues a false medical certificate, in connection with the practice of his profession. B. Public officer issues a false certificate of merit of service, good conduct or similar circumstances. C. Private person falsifies a certificate falling within the 2 preceding subdivisions. 2. Offender knows that the certificate was false. 3. He uses the same. Article 176. Manufacturing and possession of instruments or implements for falsification. Acts punished. 1. Making or introducing into the Philippines any stamps, dies, marks, or other instruments or implements for counterfeiting or falsification or 2. Possession with intent to use the instruments or implements for counterfeiting or falsification made in or introduced into the Philippines by another person. Article 177. Usurpation of authority of official functions. Usurpation of authority, no connection with the office represented. Elements. 1. Offender knowingly and falsely represents himself. 2. As an officer, agent, or representative of any department or agency of the Philippine government or of any foreign government. Usurpation of official functions, excess of authority. Elements. 1. Offender performs any act. 2. Act pertains to any person in authority or public officer of the Philippine government or any foreign government, or any agency thereof. 3. Under pretense of official position. 4. Without being lawfully entitled to do so. Article 178. Using fictitious and concealing true name. Using fictitious name. Elements. 1. Offender uses a name other than his real name. 2. He uses the fictitious name publicly. 3. Purpose of use is to a. Conceal a crime. b. Evade the execution of a judgment or c. Cause damage. Concealing true name. Elements. 1. Offender conceals his true name and other personal circumstances. 2. Purpose is only to conceal his identity. Article 179. Illegal use of uniforms and insignia. Elements. 1. Offender makes use of insignia, uniforms, or dress. 2. The insignia, uniforms, or dress pertains to an office not held by such person or a class of persons of which he is not a member. 3. Said insignia, uniform, or dress is used publicly and improperly. Intent to deceive. General rule: the offender must make use of insignia, uniforms, or dresses with intent to deceive. Exceptions: intent is not necessary under 1 RA number 492 punishes the wearing of insignia, badge, or emblem of rank of the members of the AFP. Section 2. 2 RA number 75 punishes the unauthorized wearing of any naval, military, police or other official uniform, decoration, or regalia of a foreign state or one nearly resembling the same, with intent to deceive or mislead. Section 3. 3 EO number 297 punishes the illegal manufacture, sale, distribution, and use of PNP uniforms, insignias, and other accoutrements. Article 180. False testimony against defendant. Elements. 1. There is a criminal proceeding. 2. Offender testifies falsely under oath against the defendant therein. 3. Offender knows that it is false. 4. Defendant against whom the false testimony is given is either acquitted or convicted in a final judgment. Liability of witness. Witness who gave the false testimony is liable even if his testimony was not considered by the court. Article 181. False testimony favorable to the defendant. Elements. 1. A person gives false testimony. 2. In favor of the defendant. 3. In a criminal case. Testimony need not be beneficial to the defendant. Article 182. False testimony in civil cases. Elements. 1. Testimony must be given in a civil case. 2. It must relate to the issues presented in said case. 3. It must be false. 4. It must be given by the defendant knowing the same to be false. 5. It must be malicious and given with an intent to affect the issued presented in said case. Article 183. False testimony in other cases and perjury in solemn affirmation. Acts punished. 1. Falsely testifying under oath. 2. Making a false affidavit. Elements of perjury. 1. Offender makes a statement under oath or executes an affidavit upon a material matter. 2. Statement or affidavit is made before a competent officer, authorized to receive and administer oaths. 3. Offender makes a willful and deliberate assertion of a falsehood in the statement or affidavit. 4. The sworn statement or affidavit containing the falsity is required by law made for a legal purpose. Elements. 1. Offender offers in evidence a false witness or testimony. 2. He knows that the witness or the testimony was false. 3. The offer was made in any judicial or official proceeding. Article 185. Machinations in public auctions. Crime is consummated by 1. Mere solicitation of gift or promise as consideration for not bidding, or 2. By mere attempt to cause prospective bidders to stay away from an auction. Title 6, Public Morals. Note: Articles 195 to 196 have been repealed and modified by PD numbers 449, 483 and 1602, as amended by Letters of Instructions number 816. Article 196. Importation, sale, and possession of lottery tickets and advertisements. Acts punished. 1. Importing into the Philippines from any foreign place or port any lottery ticket or advertisement. 2. Possessing, knowingly and with intent to use, lottery tickets or advertisements. 3. Selling or distributing the same in connivance with the importer, and 4. Selling or distributing the same without connivance with the importer. Articles. 197 to 199 has been repealed and modified by PD 483 and PD 449. Article 197. Betting in sports contests, repealed by PD 483. Offenders punished Section 3, PD 483 OOG. 1. An official, such as promoter, referee, umpire, judge, or coach in the game, race or sports contests, or the manager or sponsor of any participating team, individual or player therein, or participants or players in such games, races, or other sports contests. 2. Any other offender. 3. An official or employee of any government office or agency concerned with the enforcement or administration of laws and regulations on sports. Article 198. Illegal betting on horse races repealed by Act 309, as amended by R.A. Acts punished. 1. Betting on horse races during the periods not allowed by law, and 2. Maintaining or employing a totalizer or other device or profit therefrom, during periods not allowed by law. Days when horse racing is allowed versus days when horse racing is not allowed. Article 199. Illegal cockfighting amended by PD 449. Persons liable. Article 199, as amended by PD 449. 1. Any person who directly or indirectly participates in cockfights, by betting money or other valuable things on a day other than those permitted by law. 2. Any person who directly or indirectly organizes cockfights at which bets are made, on a day other than those permitted by law. 3. Any person who directly or indirectly participates in cockfights, at a place other than a licensed cockpit. 4. When the offender is the financier, owner, manger, or operator of cockpit, or the gaffer, referee, or bet taker in cockfights, or 5. Allowing, promoting, or participating in any other kind of gambling in the premises of cockfights during cockfights. Days cockfighting is allowed. Section 5, D, PD 449. Article 200. Grave scandal. Elements. 1. The offender performs an act/acts. 2. Such acts/s are highly scandalous as offending against decency or good customs. 3. The highly scandalous conduct is not expressly falling within any other article of the RPC. 4. The act/s complained of be committed in a public place or within the public knowledge or view. U.S. v. Samaniego. Acts must be performed in 1. Public place or 2. Private place within public knowledge. Note: if committed in a public place, the performance of the act offensive to decency is already a crime even though there is no third party looking at it. Public view is not required. The public character of the place is sufficient. Article 201. Immoral doctrines, obscene publications and exhibitions and indecent shows, as amended by PD 960 and 969. Distribution is the act punished. Hence, the isolated, casual or occasional act of giving such kind of literature to a single recipient is not punishable. Publicity is essential to be liable. Mere possession of obscene materials, without intention to sell, exhibit, or give them away, is not punishable since the purpose of the law is to prohibit the dissemination of obscene materials to the public